Hi, my name is Michaela Leiden, and today I'm going to be presenting on a demurrer. So to start off, what is a demurrer? It is a type of motion that asks the court to dismiss the other side's pleading because the pleading is not legally sufficient. This happens before an answer is filed. It must be filed within the time period the defendant has to answer the complaint, which in California we know is generally 30 days, which then extends the time for the defendant to answer the complaint until there has been a ruling by the court on the demurrer. Listed below, according to CCP section 430.10, are grounds raised by a demurrer, including the court lacking subject matter jurisdiction, the person who filed the pleading does not have legal capacity to sue, there is another action pending between the same parties on the same causes of action, there is a defect or misjoinder of parties, the complaint or cross-complaint fails to state facts sufficient to state a cause of action, the pleading is uncertain. In contract actions, it cannot be determined that the contract is oral, written, or implied, and certificate by the attorney of review and consult in certain malpractice actions. So according to Code of Civil Procedure section 430.41, which went into effect January 1st, 2016, which is relatively very new, meet and confer was established. The demurring party must meet and confer in person or by phone with the party filing pleading and identify with legal support the basis of the perceived deficiencies. The non-demurring party then must respond with legal support of why its pleading is legally sufficient. This must take place at least 5 days before the responsive pleading is due. The purpose of meet and confer is to encourage parties to cooperate with each other to resolve their demurrer objections of the court. The California courts were tired of hearing constant demurrers, so they've added this, intending to also reduce endless cycles of demurrers, which involves demurrers being filed, the court sustaining with leaving to amend, plaintiff files amended complaint, and then it repeats over and over again. If a conference does not take place in time, the demurring party can file a declaration saying it made a good faith effort to meet and confer and why it did not happen, and it will receive an automatic 30-day extension to respond. So here is the meet and confer document. And then here is the extension. According to CCP section 430.40, demurrers must be set for hearing not more than 35 days following the filing of the demurrer or on the first date available to the court thereafter. For good cause shown, the court may order the hearing held on an earlier or later date on notice prescribed by the court. So the different rulings. If a demurrer were to be sustained, the plaintiff will need to amend the complaint to correct the defect raised by the demurrer, or risk that the complaint would be dismissed overall. If a demurrer is overruled, the defendant will have 10 days after ruling on the demurrer to answer the complaint. So as shown here is Audrey's original complaint for Sampson versus Emerald's Catering, which I then used to draft my demurrer. So when drafting a demurrer, the caption of a demurrer must state the number of the case, the name of the party filing the demurrer, and the name of the party whose pleading is the subject of the demurrer. So as you can see here on the right is mine. And then, according to CRP 3.113, a memorandum must include a statement of facts, a concise statement of the law, evidence, and argument relied on, and a discussion of statutes, cases, and textbooks cited in support of the position advanced. So as here on the right states my memorandum, as well as the statement and the facts of the case, Sampson versus Emerald's Catering. So according to Rule .31320 of CRC, provides that each ground of demurrer must be in a separate paragraph and must state whether it applies to the entire complaint, the cross-complaint, or answer, or to specified causes of actions or defenses. So as shown on the right, I demurred to Audrey's first cause of action, stating the compensatory damages of $9,500 for reputational damage and embarrassment. I stated that this was ambiguous and uncertain because the defendants are not feasibly held responsible for reputation damage or embarrassment done on the plaintiffs. Compensatory damages normally just include medical bills, domestic services, lost wages, property replacement, transportation, etc. Thank you so much for listening. Let me know if you have any questions in the discussion board.